The European Mediation Directive. 1. Background to and aims of the directive. Shortly after the adoption of the Code of Conduct, the European Commission submitted to the European Parliament and Council a proposal for a directive on certain aspects of mediation in civil and commercial matters. This instrument was adopted on May 21, 2008, and the Member States were to have transposed it into national law before May 21, 2011. The directive in its terms did not set out to create a European mediation code. The purpose in the main was to set out some minimum standards as regards the meaning and quality of mediation, as well as ensuring that the relationship between mediation and judicial proceedings remained in balance. This was against the background of seeking to promote access to ADR and to encourage the use of mediation to settle amicably disputes in civil and commercial matters. 2. Cross-border disputes. Article 2. The directive only applies in relation to mediation in cross-border disputes. For the purpose of the directive, such a dispute is one in which at least one party to the dispute is domiciled or habitually resident in a member state other than any other party. This falls to be determined on one of the following dates: when the parties agree to mediate, when mediation is ordered by a court, when the parties become obliged under national law to go to mediation, or a court invites the parties to use mediation to settle a dispute which is subject to litigation. Another situation which is characterized as cross-border under the directive is where the parties fail to reach agreement and litigation or arbitration ensues after the mediation. If the court or arbitral proceedings take place in a member state other than that in which the parties were domiciled or habitually resident at the time when the mediation commenced, the dispute is characterized as cross-border with respect to the provisions of the directive dealing with confidentiality and prescription and limitation periods. 3. Quality of mediation. Article 4. The directive requires member states to encourage by any means which they consider appropriate adherence to and development of codes of conduct of mediators and mediation organizations. There is also a general appeal to member states to encourage other quality control mechanisms for the provision of mediation as well as the training of mediators. 4. Recourse to mediation. Article 5. The directive provides that courts may invite parties which appear before them in litigation to use mediation to seek to settle the dispute or to attend an information session. This does not prevent member states from making mediation compulsory or subject to incentives or sanctions so long as this does not prevent recourse to the courts. 5. Enforceability of agreements resulting from mediation. Article 6. An important provision in the directive, this article requires member states to ensure that an agreement resulting from mediation should, subject to certain narrow exceptions, be able to be made enforceable on the request of a party with the consent of the other. This can be done, for example, by a court decision or in another way available under the legal system of the member state where the request for enforceability is made, namely by an authentic instrument established by a notary. Either way, the resulting agreement will be enforceable under the relevant provisions of the European instruments within whose scope is its subject matter. So, for example, an agreement resolving a cross-border contractual dispute would be enforceable under the Brussels I regulation or as an EEO. 6. Confidentiality of mediation. Article 7. One of the advantages of mediation is that it is confidential as between the parties and as regards the mediator. Some legal systems in the member states make provision for this. Also, it is very common practice for parties to mediation to enter into an agreement to mediate where one of the terms of such an agreement is that the process shall remain confidential. The directive picks up this theme by providing that the member states are to ensure that neither the mediator nor anyone involved in the administration of mediation shall be compelled to give evidence in subsequent court or arbitral proceedings about anything to do with the mediation unless the parties agree or there is some other overriding public policy reason, say where the best interests of a child are to be protected if such evidence is disclosed. 7. Prescription and limitation of actions. Article 8. One of the possible difficulties about proceeding to mediation is where a period of prescription or limitation is about to expire, and this is likely to occur during a mediation. Mediation is not normally an incidence of interruption of prescription under the national laws of the member states. Therefore, this provision requires member states to ensure that if a period of prescription or limitation does expire during a mediation which is subject to the directive, this should not have the result under the relevant law that a party can no longer institute judicial or arbitral proceedings. This provision is also intended to remove one possible legal disincentive to mediation. 8. Information about mediation. Article 9. In an endeavor to spread the word about mediation, member states shall encourage the dissemination of information about how the public can contact mediators and mediation organizations. In addition, the European Commission is to receive from member states and publish